We are here once again with our Facebook live session on behalf of MR Solicitors. Today I have with me Qazi Imran Iqbal Sahab, again our guest today. So we will try to discuss again the up-to-date information in relation to immigration matters, as well as any other legal matter or issue you have in your mind. You can always ask a question. So to start with, Qazi Imran Sahab,
Yes,
we
sir.
were discussing just before starting this,
Yes, sir.
the refugee crisis
Yes,
in Europe and even in Middle East.
yes.
So what do you say, what is the scenario ongoing at the moment, and what impact we are going to have in UK because of that?
Thank you very much, sir. Basically, the European immigration crisis actually ignited in Middle East. So the Middle Eastern countries, as everyone aware, is so many things going on, especially the war and then the ISS terrorism, and obviously the middle point or where this the busting issue it started from the Syria. And Syrian refugee camps basically provided the harboring ground for all these crises. The UNO they are just turning the blind eye on the genuine resolution of the refugees. So then the people they are hungry. They don't have resources to cope with the cold, with the hunger, with the so many other social issues. They don't have medical facilities. If, for an example, it's a Yarmouk camp, which is established so many years ago, even decades ago, they don't have the basic facilities. So people trying to slide into the neighboring countries, which is Turkey, Jordan, and Egypt. Obviously, the Turkish they are very strict on their borders, and ultimately the people who take risk on their life and they try to slide into Europe. As you are aware, that recently so many in last week or week before is hundred of migrants they landed in the Dover beach of the United Kingdom.
Is this the time when this our Secretary of State Priti Patel said we have been successful in returning
Yes,
few
sir.
of the refugees, but
Yes,
the number is very huge actually.
yes,
So far, I think UK has not been successful in tackling
yes, sir.
the
You
situation. But
absolutely.
what do you see that after the Brexit, what would happen, because they will not be bound by European legislation,
Yes, sir.
but still I believe UN Convention is going to stay there,
Yes, sir.
or Geneva Convention is going
Yes.
to stay there. So what do you say on that?
In my point of view, I think the UK government will suffer more and more in the refugee crisis, because once they are out of the Brexit, they are out of the union, then obviously they are not bound to follow the agreements.
Dublin Convention, you
Dublin
mean? Yeah.
Convention, yes. So Convention technically invalidate after their departure from the union.
Hmm.
So this thing happened already. Is as few of our clients they are. It's a law in the European Union. The first port of entry should be determining the refugee claim. And in Europe, mostly majority of the refugees they came from North Africa to Italy. It's a warm if the weather conditions are good, and then they come to Portugal or Spain. But recently, so many people they claim there, they claim on the first port of entry, and then when they claim here, when it was before the Brexit and when these um, UK was bound by the treaties, so they used to send so many people back to the first port of entry, and now technically this is not possible, and so many of our clients who already claimed asylum in, for example, Greece or the Italy, and when they determine and they tally their biometric information, so they are not bound, they are not able to send them back, so they are determining as a fresh claimant here. So I think that they need the new legislation or the new measures to tackle with legal issues arising from this current scenario.
Thank you. Whilst you were talking, I took the liberty to finish my tea, my
Yes, sir.
afternoon tea. We have a few emails already lined up, and we'll encourage if you have any questions relating to immigration or non-immigration, as long as it's a legal issue, then you can send us an email or at info@m-rsolicitors.co.uk. If you need to make an appointment and see us in person, the telephone number to call is 0208 0208 1956. Always
518-1956. 0208 518-1956.
Thank you very much.
No.
These days we are on the emails, you see,
Yes.
on mobile phones, so it's difficult to remember the landline numbers. So these are the contact details. You can contact us, or in today's Facebook live session, you can send your questions and we'll try to answer today. The inquiries I have is Abdul Aziz sir from Huddersfield. You did send us an inquiry about the timeline in relation to appeals, and there are questions of timeline in relation to Home Office applications as well, considering the pandemic situations. So if I consider London tribunals, apart from Taylor House, all the tribunals, they are still conducting these hearings via video link. Only Taylor House has issued limited notice of hearings in person. We have some hearings lined up in September and October in Taylor House, which are so far in person. They have not issued further directions, so we are expecting that they will remain in person. However, most of the other hearings are still via video link, even if it is a EA appeal and your sponsor is out of UK. They are still taking you on board, and the sponsor is, for example, in Spain. The sponsor will stay in Spain in his home or workplace, and he will be linked over the video from there. Home office representative sitting in his office or home. You and your lawyer can sit together, appellant and the lawyer can sit together in his office, or you can be at your own places. The judge is at his place, and the court's clerk is normally in the court or somewhere else. And similarly, if there is an interpreter. So 5 to 6 people minimum at the same time. It is a difficult one, but however, the situation is as it is. The timeline is, once, if you do receive a refusal letter, the standard directions are then within 42 days you need to submit your bundle. But now what they have done is most of the time the court issue a hearing date, which is CMR, case management conference, you can say, or case management review hearing, you can call it. They conduct that over Skype or over the phone. And then they try to narrow down the issues. If there are 20 issues in your refusal letter, the judge normally try to ask the appellant side and the Home Office side that to narrow down the issues. And if there are issues which are not going to be very relevant, or there are concessions to be made, then the judge try to get the both parties agreed to a few points, and then the hearing becomes shorter. So this is an advantage actually. So when you are doing the CMR hearing, your representative, he would be in a better position to tell you that these are the issues where we need to concentrate more, because the judge has specifically concentrated on these or focused on these particular issues. So once that is done, then obviously the decision is still, they say 2 to 6 weeks. Normally it is coming within 3 to 4 weeks. Now the difficulty is on those appeals, as Abdul Aziz, you have specifically asked, the tribunals where the permission has been granted and we are waiting for the tribunal hearing, whether it is going to be by upper tribunal itself or they are going to remit back to FTT. This is the problem, where we have not received the hearing dates yet. We have received the permissions where they have given the permission that there is a permission to appeal, but however we are waiting for the hearing dates. Considering the backlog, we have been trying to send emails to the court, and we do receive response, and the response is only that yes, it is pending and we'll get back to you as soon as practicable or as soon as the date becomes available. So probably the judges are in few in numbers, because when you do the hearing over Skype or video link, it tends to take more time than the normal hearing. And then there are technical issues as well. So it is very difficult to envisage or confirm that what is the time span or time limit. There is no time limit and the procedure. It should be done as soon as possible. But considering the pandemic situation, this is how it is. We normally used to say about until a month ago that, look, it should be around within 3 months or so. But there are cases where we have passed even 4 months. So we are chasing the courts. Unfortunately, we are not getting very helpful, useful information from them, apart from, okay, yes, it is still pending. In terms of Home Office applications, the new applications, as most of you know now, if you have submitted application once before and this is just kind of an extension application of spouse visa or 10-year route visa or any other route where you have student visa even, you are applying for extensions, very likely the Home Office is not going to give you a date for biometrics. What they are doing is once you submit the application online, you have around 10 days to submit your documents, and your documents you can upload, your lawyer can upload, scan them and upload, and once they receive those, then they issue you a direction. They send you normally an email. They have started this app system, ID verification system, where you download the app, you go through that ID verification system from your mobile, and you send them your ID, like a photo, and sometimes they do ask for a passport or a card as well. So you upload that at that time, and then they don't ask you to come and do the fingerprinting biometrics. However, if it is your first application, then it is going to be biometric at the moment. This is what they're saying, but until now we have not received any single date of biometric for those applications which we have sent in last 1 to 2 months. The applications which were submitted before pandemic situation, like in April or early March, we did receive the biometric dates, and they did decide those cases. So again, from the date of certificate they issue, or I would say now the date they will take the ID verification, probably it should be done within maximum 6 months. That is the timeline they already used to say, but it is yet to be seen, because I would say the testing time started from like August, when officially they started opening the centers from early August. So situation is still very much uncertain, but we will try to keep you up to date. If you have any specific question, you can always send us a question and we can respond to that. We'll see if there is a question here. I think there are questions. So welcome to all of you. I can see quite a few familiar names, and our professional friends are watching as well. So there is Mr. Sonabat, welcome. You said I had settled status under EU scheme. My wife is EU national and my parents had pre-settled status. My wife is sponsoring my parents. Now if I give divorce my wife, any problem, my parents' visa, my parents is extended family member of EU national. Okay. Well, when you make a settlement application under EU, because it is going to be EU settlement scheme, whether it is EU 13, 14, 15, 16, 17, these are the paragraphs you would be relying on. If you are applying for EU settlement, you have to still state that you have lived with your European sponsor for 5 years or so. However, again, there are exceptions, the retained right exceptions. So you need to go through those legislative scenarios where if you divorce your wife, still you can go ahead similarly like it used to be before, retained right, that you have the marriage did survive for 3 years at least. So then you can go for retained rights. So similarly for your parents, if you do give her divorce, but there was a relationship of 3 years or more, your relationship, then whatever your status would be, you should be applying for your parents as well under retained right, and they should be able to get 5 years visa again from that date. However, as soon as you and your parents complete 5 years from day one, then you can still go for settlement visa without your wife. But if in your specific circumstances, it would be better to take a face-to-face appointment either with ourselves or with any other lawyer to give you further advice on that. As I always say, that we try to give general advice because sometimes this general advice does not fit your purpose. So it's better to take particular advice. Thank you, Alijan. You are still waiting from me the situation on Canadian immigration. Canadian immigration, unfortunately, the embassies, like for example, Canadian embassy in Pakistan, they haven't started taking the application. So we are still in difficult situation. Yes, there are options available for work permit, student visas, investor visas, There are many investor visas categories for Canada. However, we still need to wait until November. We thought probably from September they'll start. However, now we need to wait until November before we can advise you further in new applications for Canada. Another question, welcome madam. The question is, can someone sponsor his mother while on pre-settled status? You can only sponsor for like a visitor visa unless you are on settled visa. So you cannot sponsor your parents if you do not have settled or indefinite or permanent status in the UK, but you can sponsor them for visitor visa. However, if your sponsor is also related, which I believe will be related to your parents, then definitely you look into the regulations. They can apply on their behalf for settlement as well. But as I said, for visitor visa, yes, anybody who has status in the UK, whether indefinite or not, can sponsor people for visit visa only. The other inquiries we have here is in relation to student visas. Yes, the question was, if I come on student visa now, will I be able to get this 2 years work visa announced by the Home Office? Yes, it is true. Anybody who is coming now, in fact, who has come from January 2020 onwards, is likely to finish the shortest degree, which is a master's degree, for 1 year and so 1.5 years, 16 to 18 months. So you will be completing your degree after summer. Summer means June 2021. So if you are going to finish your degree after June 2021, then you will be eligible to go ahead with this PSW kind of work visa. It is open work visa, which means that you can find job and do work with that particular employer. You can work for more than one employer. You can do your own business. So that is there. It is pretty much same as PSW visa we used to have before. After that, still you have option to extend your visa, not in that particular category, but however, you can switch to startup visa, you can switch to innovator visa, you can switch to work permit visa. And related question was that some time back I did say that there is going to be another category similar like to highly skilled migrant program. Yes, I did say that, and I stick to that because the MAC Migration Advisory Committee or Council did propose this, which Home Office had. All these, even the student visa, work visa after student, or the work permit changes which are going to happen from January, they were all proposed by MAC, and Home Office has taken them up. So they have also proposed for highly skilled migrants, and Home Office is going to take that on. I cannot be sure that when they will start, but it is my personal thinking and imagination. You can say that they would start after Brexit. So about March, April, probably we will have another announcement for those people who are highly skilled. Similar program as we used to have, a highly skilled program, points-based kind of system for those people who are highly skilled and they don't want to take work permit route. They want to come and establish their own business. So it would be for them. So students, yes, you can come, and we have also started this facility. If you want to take admission in the UK and you want to choose which university would be best for you, and you want to choose which course should be best for you, you can send us your query with your brief history at admissions at m-rsolicitors.co.uk. Admissions with ADMISSIONS at m-rsolicitors.co.uk, and we will help you to take admission in UK university and as well as help you with the application process. You can also apply directly for obviously startup visas as innovator visas. We do get at least 20 to 25 queries a week via emails, and most of the people, they do not understand what is innovator visa and what is startup visa. They just say that, okay, I have done degree and can I apply for startup visa or can I apply for innovator visa? So a very basic requirement of both categories is innovative business plan. Very basic requirement is that particular business plan has to be viable and scalable. Viable means it has to be practical. that you are not considering a dream. It's a real business project. And scalable means it is progressing. Every year you are showing progression. So your business plan, 3 or 5 years business plan should show that every year you will building up upwards, and it is an innovative. Innovative does not have to be a very new idea. The idea can be which has already been implemented in UK, but there is still a scope, a room for that, and you can do that. So the starting point is your innovative, viable, scalable business plan. And then obviously English requirement is there, B2, and then maintenance requirement is there for 3 months, 900 and some pounds. And for this is for both categories. For Innovator, the extra requirement is that you should have funding at least for 50,000 pounds. But it does not mean that you cannot show more than 50,000 pounds. It will depend on your business plan. If your business plan says that I should have 200,000 pounds, then you need to show 200,000 pounds. And that 200,000 pounds or 50,000 pounds, you don't have to show for last 3 months. It can be put like a day, a week before. So the business plan will be endorsed by these endorsed bodies. If they do endorse, then you can continue, go to the next step, which is the application process. Still, Home Office can refuse your application if they are not satisfied that the endorsed body has taken proper steps to evaluate your business plan. So this is, I think, basic information you needed. So if you do think that you have a business plan which fulfills this criteria, then definitely you should consider these categories. Anything, Imran sir, you wanted to ask before I move on to other areas?
Sir, is it's my favorite topic, human rights and the asylum. So
Yes.
There is new figures about the people who are destitute, and it's very concerning for the civilized world due to these unrest. So many factors, obviously: wars, civil wars, human rights violations, environmental and climate issues, economic hardships. These all factors led 21.3 million people suffered. So this is a point of concern. The majority of them, unfortunately, they belongs to the Middle East and the Muslim countries and the African countries. So this is a point of concern, and people, they put their life on risk to get to the safest places. But unfortunately, the legislations here are so complex, so people don't get right to live here straightforward, and sometimes they have to struggle years and years to get their due status and the expectation which they built up in mind when they come here. Obviously,
So advice is, if you want to come to UK, try to use the legal way out.
ways, yes, exactly.
Whether it is a student visa, visitor, you want to come, there is a
Yes.
business
Yes,
sole representative
Yes,
of an overseas
yes.
business, and wait, there will be more categories, as I said, for highly
Yes.
skilled people. So you need to use the legal
Legal
ways
channels,
to come over. We have further questions, and welcome again to everybody. Simpson, you asked a question that I want to have a work permit. Very general question. If you want to have a work permit, then you need to have an employer in the UK who require a skilled person from abroad if you are abroad, and before that they have to have a sponsorship license from UK Home Office. So if you want to ask further, you can send us an email on info@m-artsolicitors.co.uk. But it's not like that you want work permit and you say yes, you can have work permit. It's not like that. You have to apply for those particular employers, and it'll be difficult for us to just choose any employer for you. So that would be an exercise you will have to do. However, if you have some qualifications in relation to those categories which are in shortlist occupation, then you have to take that route. You need to see there are different websites where these kinds of jobs are advertised, so you need to take that route. I hope I made some sense to it. Another question from Akil Ahmed. Welcome, Akil. I did my TOEIC English language in 2011. Now I have ILR, need to apply citizenship next month. Home Office never concerned about my TOEIC test, never had deception. If I apply citizen, are they going to concern? Okay. When you make an application for naturalization, the general rule is they can go back, actually they do go back up to 10 years if you are in the UK for 10 years or more. So they go up to 10 years. So if you did your TOEIC in 2011 and you see that the TOEIC was a genuine TOEIC, you did it yourself, there is no issue with that, then you shouldn't be worried about it. And just add the certificates with that if you think that you need to give justification. But if the Home Office just given you ILR and they did not raise any issue on TOEIC, I don't see that they will do that again, but it is in their discretion. So if you think you are not sure what happened to your test, then you better wait for another 1 year. So once it's 10 years altogether, then you go for naturalization, as long as you already have passed 1 year after ILR as well, because this is another requirement that if you got ILR on the basis of 10 years or 5 years, apart from spouse visa, then you have to wait 1 year after ILR. And when we say that unless spouse visa, so if you got indefinite leave to remain because you were a spouse here and you got indefinite leave to remain, then yes, you do not have to wait for 1 year. You can apply next day, but there the condition is your spouse has to be British national, not a settled or refugee person here. Okay, Mohammed Asghar Sahab, welcome, and Walaikum Salam. EU Settlement and Regulation 9 extended family members of treaties rights used by British citizens, same thing. Okay, regulation I couldn't understand properly, but if I understand it this way, that Regulation 9 is to do with extended family members of British citizens. That is true. Now, EU settlement scheme, if you're talking about, EU settlement scheme has been introduced because this is the settlement scheme they will be using and relying on after Brexit, but they have started. And all those people who are European nationals who have not applied for pre-settled or settled visa, they must do so if they are in UK by 30th of June 2021. Otherwise, the deadline is 31st of December. In that particular EU settlement scheme, the British nationals who have come back from European states, they do not have to apply for settled or pre-settled visas. However, their dependents, those people who have already obtained visas as their dependents, they can apply for pre-settled or settled visas. But please be careful. If you have not had any visa as a dependent of that British or European settled person, European national, you cannot use this EU settlement scheme. You still have to go through the old scheme EEA FM or EEA EFM application forms. There are few cases, and we have witnessed few cases where people did not have that visa and they applied and they did get the visa. I cannot comment on that, but actually I can say this is definitely a mistake on the Home Office part, because there are cases where Home Office actually has written those applications, has written email to clients that you have used the wrong EU settlement form. You're supposed to use the other form, so we are withdrawing your application. You're sending back the documents, so you make that application. So sensible thing is to apply under old rules. That would be better. Abdulaziz, thank you for saying useful session. Ahsanullah Muhammad, welcome sir. You say that I lose 10-year ILR, I lose human rights appeal for advice. My previous listers probably want to say, now today I received provisional decision, probably you want to say provisional decision from legal ombudsman, positive response, poor service, my previous list. Okay, so as I understand that you are alleging that because of your previous lister's poor service, you lost your case and then you made a complaint to legal ombudsman in SRA and they have given this decision. Unfortunately, if you use that there you were ill-advised by a solicitor, normally Home Office, they do have the discretion to consider in your favor. So if you have this and you think other aspects of your case are strong and this was the only issue that because of their negligent service or poor service you lost this, then I would advise you to take this action further. If it's not too late, send Home Office a reconsideration application. If it is too late, then you need to make a fresh application with all these factors, add everything you want to add, and don't just rely on whatever you relied before. Try to add something fresh, some fresh evidence as well, so the Home Office can consider the whole scenario. I hope my answer would help you. Otherwise, I would recommend that you take proper advice face-to-face session. Muhammad Abid Khan Sahab, thank you for watching our live session, and so many other people. It's difficult for me to mention everybody's name. I'm just trying to flick through if I find more questions. The other questions were actually related to immigration and family matters together. And the question was contact order. A person who came here on a spouse visa and he stayed here for 2 years, 6 months left, and things didn't go well, and there is a separation between the couple. And there's a child as well who's a British child. So he asked how he can have access to his child and whether he can take any benefit out of it towards his immigration. So yes, there is immigration paragraph 248 if you are in UK, and if you are abroad it is 246. Those people who are abroad and have British children here, even though they are not on even terms with their spouses, they can use paragraph 2462. It is called access access to child right visa. So you can get a contact order through family court if your wife or ex-wife is not allowing you to see the children. So you need to make an application to the family court with birth certificates of your children. If you do not have birth certificate, and people say that we do not have birth certificate, how are we going to get it? So you go to the registration office, you are the father, you can just show your ID and you will get the birth certificate of your child or children. So once you get the original birth certificate, then you make application. You can make this application online, submit to the family court with the birth certificate, and you will get the hearing date. Or at the hearing date, it will start as a direction hearing these days. Again, direction hearings are over the phone, even hearings are over the phone. So if there is no history of violence towards the child, then very likely 1 or 2 hearings you will get contact order. So once you get the contact order, you will be able to see your child. That's one. And secondly, you can make an application on the basis of that child contact order to Home Office, and you will get further visa depending on your circumstances, either another 5 years visa, 2.5 years visa, and after completing 5 years, where you can add those 2 years which you have already spent. So after completing 5 years all in one go, or in 2.5, you will be eligible to get indefinite leave to remain. And you wanted to add something there?
Yes, that's fine. But if you shed some light on the recent changes in the fees waiver and the condition created by this pandemic.
Yes.
So many people are curious, especially with the leave to remain, and they wanted to ask whether what remedies are available for them to switch their categories to recourse to public fund or similar benefit package from the government.
That is very useful. We have been discussing this in our previous sessions as well, and there has been a court decision as well a couple of months ago. After all those people who did get status from the Home Office under human rights, the 10-year category for an example, and their immigration status, the residence card states no recourse to public funds. They can change the conditions of their status, and they can claim benefits, but they have to submit change of condition application to the Home Office, which is free of charge. Yes, legal representatives, the solicitors may charge you their fees if you are using them. Otherwise, if you want to do it yourself and you feel confident, then you can submit that application to Home Office and your conditions will be changed, and then you will be able to claim benefits. The only big requirement is that you have to show that you are destitute. You cannot afford to make your living out of it. So normally what they want you to submit is your 6 months bank statements to see how much money is coming in, how much money is going in. So you need to do your homework. How much is your expense? How much money is coming in? Or if you are getting any support from any family, friends, you need to mention their name, their bank statements, their letter that yes, they have been supporting you and why they cannot support you anymore. So on those basis, your conditions on the cards will be changed. And this is very true for those people as well who would like to make a new application and they cannot afford home office fees, because home office fees per application is about 2,053 pounds. So if you cannot afford that, then you need to make fee waiver application. So if you are already on visa, you do not have to wait until your visa is coming to an end, because these applications do take time. This is not immigration application. You cannot consider that, okay, my visa is expiring. If I send this application, I'm legal even if my visa has expired. This is pending. No, this is not immigration application. This is visa fee waiver application. So again, the requirements are same. You submit your application, and if they decide in your favor, then straight away within few days, I believe 10 days or so, you need to submit your application with this fee waiver approval to the Home Office, and they will give you visa. And again, it will say recourse to public funds allowed. So this is very, very important. Still people are coming to us and they probably did not hear this information. They are suffering financially and they cannot take benefits because it says it's not allowed. Yes. So we tell them, look, it is allowed. You just need to change your conditions on your card and then you are able to apply for those benefits. I think there are a few more questions, but we'll try to answer those even after the session, and the emails, the new emails we have received, we will try to answer your queries as well. Again, if you have further queries, you can send us email on info@m-rsolicitors.co.uk. If your query is regarding admissions to UK, because so many people from abroad are watching and they are sending us queries, it's better you can send your email to admissions@m-rsolicitors.co.uk. But if you have sent or you send on info as well, it's still okay. If you want to make an appointment to see us in person or telephone appointment, the number is 0208 518 1956. I think I got it wrong right this time, is it?
Yes.
Is it right? Yeah. So it's 0208 518 1956. So until our next session, unless Kali Sahib, you want to add anything else before we say goodbye, or is it okay to say goodbye?
That's fine, sir. I just wanted to add this. Please use the legal channels and the legal way to enter and to settle in the European country rather than to kill yourself at the European borders, which obviously the situation is very bad right now, according to UN sources.
Yes. Yes. Thank you very much, Kali Sahib, once again for your precious time.
Thank you, sir.
Always here, and a lot of people like you sitting here, I have realized that. So thank you very much. And everybody who took time to watch our Facebook session, so please stay tuned. Whenever we are on, we'll let you know. So if there are any queries, do not hesitate to send us. And obviously this is free live session. The queries you send, it's all free. So it is a little service from our side to the community.
Yes.
So please do pray for us, and may God keep you happy wherever you are. So stay safe. Until next time. Bye-bye.